afternoon, everyone. I'm Molly Van Houweling. I'm one of the faculty directors of the Berkeley Center for Law and Technology, and I'm delighted to be introducing our keynote speaker. Tino Cuéllar is the 10th president of the Carnegie Endowment for International Peace. He's a former justice of the California Supreme Court and has served in 3 different presidential administrations and was the Stanley Morrison Professor at Stanford University. He's a member of the American Academy of Arts and Sciences and serves on the boards of Harvard University and Inflection AI. Throughout this career, Tino has been remarkable in his ability to anticipate and understand the impact of new technology on society. Most recently at the Carnegie Endowment, he's been working with colleagues to write persuasively about how AI development can be shaped to serve the public good. And I really can't think of anyone better positioned to talk to us today about AI governance from the perspective of civil society. Please join me in welcoming Tino Cuéllar.
Good afternoon. It's great to see you all, and thank you, Molly, for that very kind introduction. I'll try to live up to it. After I hear an introduction like that, I'm reminded of the need to stay grounded and humble. And for that purpose, I can quickly remember my kids, who are 18 and 20 now. My son, to just give you a little context, when he was much younger and I was named to the California Supreme Court, he said, "Dad, why couldn't you be on the real Supreme Court?" And then, as if that weren't enough, my daughter, just not long ago, just literally about 6 months ago, I said to her something like, "You know, I really like talking to you because you listen to me very calmly and, always are able to just absorb what I have to say and then give me a reaction." And she says, "But Dad, it gets a little predictable." I said, "What are you talking about? How can I possibly be predictable?" She said, "Do you want to know how you sound to me?" And I paused there. I thought, this is a risky thing. Maybe I should just say no and call it a day. But I said, "Okay, how do I sound to you?" Like she says, "Democracy, democracy, institutions, institutions, California, artificial intelligence, democracy, institutions." I thought, this is not good. So in that same spirit, I hope that you don't I end up feeling like I sound too much like my daughter thinks I sound. But I want to just take 15, 18 minutes. Just bear with me a little bit. And then, we'll have a little time for some questions and conversation. I always learn a lot from the questions that audiences have. And in that time, I want to channel a little bit the Molly, whom I've been lucky enough to know for many years, and is a remarkable intellect and force in this field. She asked me to talk a little bit about the role of civil society. It's an interesting and strange time to be talking about the role of civil society because my colleagues in DC, where most of the Carnegie Endowment staff are, where I just came back from, are spending a lot of their time just trying to keep track of what is going on today. What happened in the Oval Office a few hours ago between President Zelensky and President Trump, Vice President Vance? What happened 2 days ago in federal court around the use of some of these digital tools to understand and control some of what the federal government is doing? So I cannot ignore that backdrop. But I also want to take a step back and say, to my mind, what I have learned as a former judge, now almost 4 years in the civil society space at Carnegie, is that a critical role for civil society on technology, on AI, on democracy, on institutions, on any of those issues my daughter hears me talk about, is twofold. First, it's to buttress important social realities and elements that protect values that we broadly, the public considers important. Public consultation, treating people with dignity, making sure different voices are at the table in important decisions. Second, there are always market failures, even in the marketplace of ideas. And a critical role, to my mind, for civil society is to help identify and fill those gaps in the discourse. What it is that you are talking about in this very room that is not making it to the discussions in DC or maybe even in Sacramento. So I want to spend the next 12 or 13 minutes with you highlighting what I take to be an interesting gap to some degree. And like all gaps, I'm not saying that it's completely empty. Some of what I'm going to share with you is being talked about to some degree. But I'm trying to give my 2 cents that the discussion is not fully taking into account this set of issues I want to put on the table. So I'm going to channel the fact that I happen to be a lawyer. A number of you are lawyers. This conference is being put on by, to some extent, a law-related organization. But I think what you're going to hear from me is that the main point I'm trying to make is very relevant to lawyers, but it's even more relevant to all of us who care about what the non-lawyers are thinking and what these models do when they're deciding questions that are not strictly legal. What do I mean? The conversation today so often focuses on two kinds of intersections between law and AI. The first is how AI might change the legal profession. You've probably heard something about that at this conference. I hope you do. It's an important topic. So when I was on the courts, I remember being quite struck by the enormous gap between what legal services we wanted society to be able to provide to people who couldn't afford a lawyer and what the reality was. 6-7 million cases a year in California. The vast majority of people who interact with our courts don't have a lawyer. And oftentimes when states think about what it is to provide legal services, they think about the kind of all or nothing proposition of either get a lawyer, trained and licensed, or kind of nothing. That is already beginning to change. Utah's got an interesting regulatory sandbox. There's been discussion here in California. But all those discussions about how will law affect the availability of legal services, the practice of law in law firms, the efficiency of lawyers, that's one conversation that's out there. I don't need to add to it today. A second conversation that tracks a little bit the panel you were just hearing is what can or should the law do to AI? How should AI perform differently, be used differently, be available differently, be specified differently because of legal decisions, court decisions, civil liability judgments, regulations? I've written quite a bit about that. Some of what I'll talk about today touches on that. But there is another law and AI conversation that to my mind is not as well represented in the discourse. And that is in how law-related reasoning, the kind that encompasses familiar analytical problems to lawyers and to people who study the intersection of law with the political and economic forces around it, how those judgments are constitutive of AI design itself. It is, to my mind, no accident that the language of the law permeates some technical discussions of AI. We talk about guardrails. We talk about constitutional AI. The law struggle to reconcile aspirations with reality, justice with political economy, abstract principles with concrete cases, mirrors, to my mind, AI's fundamental design challenge. My hope for civil society over the next, let's say, 24 months is that some of that insight will come a little bit closer to the heartland of what is being talked about. Consider, for example, an AI model trained to help government officials make policy decisions. And just to pick one completely at random, should we change the way the US gives out foreign aid? Okay. Should that change be implemented through a process change or a modification in the substance of who gets aid and for what reasons? The model confronts the same substance process dialectic that courts navigate every day. Similarly, distinctions between law and fact, interpretations of statutory provisions involve the same type of reasoning required when an AI system interprets ambiguous user requests or balances competing values. Let me give you another example. If you've ever followed constitutional law, you know that there's something called just compensation. The government says, you know, you own this nice house, by the way, we're just going to take it because you have to build a highway through this. We can't just let the government do that without providing some just compensation. What the nature of the compensation is depends on the nature of your transaction with the government. What it is the government is taking away, what, if anything, the government is giving you back. But as Darrell Levinson, a law professor I much admire, has pointed out in his work, what counts as a transaction? What is the time frame in which you are evaluating the relationship between the person losing their house and what the government is giving back? Do you count what the government might give back in 2 months, in 6 months? Do you count the value of what that road will do for the person when they live in another house somewhere down the line? There's some judgments in courts that deal with this, but the main point Darrell Levinson was making is that that is under-theorized, like how exactly you count what is a transaction. To my mind, the solution isn't simply to make models more transparent, to make models show their work the way the O3 reasoning model does. Foundation models can certainly generate plausible sounding explanations of their interpretive method, but the critical question is whether those explanations accurately reflect the model's actual reasoning process. That's trickier. In fact, that depends entirely on how the model was trained and fine-tuned. And what we need, if we take this law in AI agenda more seriously, is a way to evaluate the match between explanations and reasoning to establish whether a model's claimed interpretive method, chain of thought, actually aligns with its decision-making process. That runs a little bit through the audit discussion you were having in the previous panel. So to my mind, the law's contribution to AI lies in centuries of wrestling with interpretation, with value pluralism, with institutional constraints. But we must approach this contribution with eyes open to law's complexities and its limitations, to whether law can actually deliver sometimes a solution to pretty intractable and difficult problems that arise in part because of the contradictions in the human mind itself, not with any drafting problem in how a particular rule or standard was written. To my mind, oversimplifying law's nature or its capacity to reconcile competing goals sets up AI for failure in meeting human aspirations, which, as most of us know, is difficult enough to live up to already. All of this conversation is playing out against the backdrop of a couple of key trends that I would argue complicate the conversation about law and AI, the conversation you're trying to have here about AI and governance. The first is that AI systems have been mostly experienced by the public that uses them as standalone systems that an individual user interacts with and gets text back from, or code, perhaps. But I tend to think that the predictions that we're on the verge of an era of agentic AI, of AI agents that can go and do stuff for us, are probably not completely overblown. We'll see where we are in a year, and I'm not suggesting that in a year we're going to have agents that do everything we'd want them to do. But are we going to have agents? Are they going to be able to make decisions about how to book reservations, how to scan through massive amounts of information that we need and give us the choice bits that we need, that are able to recommend to us more constructively what it is that our kids should do over the summer and then go and book that? I think the answer is yes. I wouldn't bet against that. That means that we are looking towards a future where agents will increasingly be interacting with each other, trading information, likely developing their own language to do so, probably engaging in what we lawyers call incompletely theorized agreements. So agreements of convenience between two agents that don't necessarily represent a deep alignment between how agents interpret the commands that they've been given. That will only complicate this question of unpacking what exactly has been driving a particular set of trends that involve AI. Second, societal level judgments about how quickly we deploy different kinds of AI systems are going to be complicated by competition dynamics between different countries and different companies. Let me just double click on the country piece. You could have the perfect strategy to evaluate a particular piece of technology and when and how it should be deployed by police or by the military. But in a competitive environment, particularly with respect to military decisions that involve judgments about what potential adversaries are doing with their militaries, and where those adversaries are constrained on a lot of dimensions that make American military power particularly salient and powerful, so money, hardware like aircraft carriers, personnel, then you're likely to face a degree of competitive pressures that will accelerate the cycle of deployment, even if you're not entirely certain how a particular piece of technology will perform. That has pros and cons. Third, in a very carefully deliberative polity domestically, where you have courts and Congress and states and other institutions, civil society, all in conversation, you can make some careful judgments about what standards should govern how an AI system makes these law-like decisions. But that's not the system or the situation we're living in right now. There are plenty of other things happening around us that are taking up plenty of the agenda of courts of Congress that are eroding, in some cases, the capacity of government experts to think through problems. So you can expect that less technical, precise, NIST-style deliberation is always going to rule the day. 4, plenty of polarization has been creeping into my mind from civil society and discussions about policy more generally into the world of AI. These days, if I just say open weight, open source, I can get a conversation or even a really intense debate going between even 3 or 4 of you. Sometimes that's a good thing. I'm not saying that we should always aim for consensus, but it does mean it complicates the discussion of these issues. And then finally, economic uncertainty. I suspect that as agents come online, the level of anxiety about people who are historically in parts of the economy that have been a little bit more insulated from automation, those concerns will grow. So a couple of implications if I put all that together, and then I'll wind up and look forward to our conversation. First is that some of the debates about how to deal with the law-like reasoning properties of AI systems is to let the market decide. And I just want to highlight here that the notion of what does it mean to let the market decide is a little bit under-theorized. I keep trying to find an alternative to the phrase under-theorized. It's a very law professor phrase. Maybe you can come up with a better one. But it's just not thought through super carefully sometimes. What do I mean? Well, essentially, if you treat a property of an AI system as unregulated, beyond the reach of a specific statute or regulation, that doesn't mean it's not touched by the law. It's subject to tort, contract, property law, all these doctrines of the common law that will often have something to say not only about how AI systems make specific legal decisions, like how it is that an AI system decides whether you should hire an employee or not and recommends it in very persuasive terms to you as a user, but also how an AI system makes law-like judgments about whether it's prudent to invite somebody onto your property when you're still remodeling your house and a big giant board might fall on a 7-year-old kid, right? So those kinds of judgments, left to the market, really in some sense mean left to the courts. Do we like that? Is that the best system to decide? It could be, but I just think we have to be clear and understand that there is a broader context around what the market means. Second, probably like many of you, it's hard not to be a little enthusiastic about the potential for some of these AI technologies at the frontier to have a real impact on human welfare in a beneficial sense. I talked to you about legal services. I could tell you about the kind of tutoring that our kids often have access to, but so many other kids don't. We could talk about medical care in the developing world. We could talk about sustainable agriculture. But the risks are there too. Risks of people being misunderstood, risks of people being given advice that's the wrong advice, risks of the democratization of a kind of technology that enables people to do things that we consider harmful. I tend to think that the way of balancing benefits and risks will require quite a bit of public deliberation, and I think there is a path forward, but it is a narrow path. And I think it's worth remembering that that path runs through how society calibrates these law-like judgments that these models are making. Third point, legal experimentation probably plays a critical role in getting the balance right. So I believe in federalism. I think that's one of the real strengths, maybe even the genius of the American system. And the fact that we don't have a one-size-fits-all across-the-board federal statute preempting all state experimentation in this area feels like a probably good thing. I think it makes civil society more effective too, to have not all the big questions be about how you can persuade or whether you can persuade the federal government. The last big point I want to make is about design choices involving human-computer interaction in the design of institutions. So much of what I've shared with you comes down to, let us not treat UX design as this little technical piece of a much broader discussion about the role of AI. It is the discussion in some sense. The question of how a UX design should enable and affect a kind of optimal degree of trust and distrust in the human user, what it should surface, how much it would highlight to the user or should, the interpretive method that the model is using all the time to interpret the commands the user is giving. Those are hard and interesting questions, and they get to the heart of like what life we want to live, right? Do we want a model that forces us to be consistent, or do we want it to feed into the natural human tendency to want one thing at time one and to want something totally different at time two, to have our behavior be one thing and our words about what we want be another? How much do we want the model to constrain us? What I'm asking for, in a sense, is a little bit more deliberate attention to those questions, not only at the individual level, but at the societal level. So in closing, by now, pretty familiar point, the relationship between humans and increasingly commoditized kinds of artificial intelligence require more than technical fixes to how to solve particular problems, how to split rules versus standards. We have to recognize instead that the pervasive judgment calls that AI systems already make, interpreting competing provisions, drawing lines, applying principles to facts, reconciling aspirations with values, how to deal with political constraints, all of those things are subject to this sort of law-like reasoning that deserves to be a little bit more clear, more transparent, more subject perhaps even to the virtual equivalent of a multi-member court deliberating inside the same model, highlighting to the user how different interpretive methods lead in different directions. I don't think that this means that we're on a completely wrong path, but I do think the path forward requires both ambition in imagining AI's contribution to human flourishing and a little bit of humility in recognizing the challenges of alignment with democratic principles. And crucially, in recognizing how much it is that the technical judgment calls that are being made right now, mostly by engineers in the business world, are not at all that foreign from the problems we've been struggling with as lawyers and as people living under law for hundreds of years. So let me stop there. Colleen, nice to see you again.
Nice to see you, Tino. Thank you so much for that great speech. So I want to go back to your initial points around the role of civil society in making sure different voices are there and heard, and sort of buttressing important social reality, and then also filling gaps in the discourse. And I want to juxtapose that with what we saw in Trump's first executive order on AI removing barriers to American leadership, and the kind of statement he wrote around developing AI systems that are free from ideological bias or engineered social agendas. And so what I want to ask is, what do you think in terms of civil society's role, not only to surface voices, but also to order them or to sort of figure out where the greater priority is? And I want to juxtapose that a little bit with the comment Jennifer Urban made earlier in the work that she's done, amazing work at CPBA, and trying to make sure that they get a robust engagement from civil society as well. And what I've always sort of struggled with is what we have a turnout problem, not only in voting, but also in who engages in lawmaking. Not everybody has the time or the inclination or the education or the ability to engage in civil society. It's a luxury for many people. And so it's kind of whichever civil society sort of issues get popped up as the hot ones that end up setting the agenda. But they may not be the most important ones, right? In terms of thinking about, well, we have a reading problem in the United States. That's never popping up as the most important AI problem that we need to address, but perhaps it is, to make sure that our kids are reading at grade level. We don't have a lot of hue about that, but we do about these other kind of headline stories. So I'm just trying to figure out what civil society's role is in that kind of interplay, and also this particular part of the Trump agenda. Thanks.
Thank you. Great question. I want to think further about it because it's a big question, but I'll highlight two things that are top of mind for me. You can't expect elections not to have consequences, of course. So in some ways, it was not entirely surprising that the first Trump AI-oriented EO repealed the Biden EO, although interestingly enough, it did not repeal the National Security Memorandum, something that I find important. But there is also, at this particular moment, an exceptional degree of noise about any policy issue, and particularly about things involving the information space. So one aspect of, to my mind, the gap filling and the reinforcing of important values that I hope to see from civil society is just bringing a little bit more clarity and sharp, trustworthy information about what's actually going on. I'll give you an example. I think there are legitimate reasons one could argue with some of the conclusions in that Biden executive order. But it was really not, to my mind, a set of top-down regulations that were pervasive across the AI space. It was many things, but it's just hard to describe it at that. I think what is getting lost is that you could legitimately disagree with the order and not call it a set of top-down regulations pervading pretty much every aspect of AI development. So that's one piece. The other piece, to my mind, is about how an important subplot in the tech policy conversation in the last at least 10 years has been these unlikely alliances that occasionally form between, let's say, the Josh Hawleys and the Elizabeth Warrens of the world. And I may not agree with a lot of their conclusions specifically around how they view the California-based tech sector, but I think part of what I'm hoping for is in this notion of greater transparency to how AI decision-making occurs, a possibility for some coalitions that are not always going to be ideologically in sync with each other on everything else. And I mean, this is a little beyond what you asked me, but I'll just note this comment, which is years ago when we were in the Obama administration, it felt to me there was a degree of polarization around discrete policy issues, and the polarization now feels different. And there are going to be times when that provides a little space for coalition building.
Thank you for your thoughtful comments. I wanted to get your sense on the power asymmetries between civil society and companies in light of the market concentration in the frontier model space and cloud providers, in terms of lobbying resources, in terms of information asymmetries about how proprietary models actually work. So do you see a role in antitrust, both kind of theoretically and pragmatically in this moment? Thank you.
Yeah, I think it's natural for civil society to be interested in not only the design of models, the use of models, legislation and regulatory approaches to models, but also at the end of the day, who's got power over the judgment calls of how these models are built and made available. I do think, two things are making that an interesting conversation right now. One is the open weight release movement, which has its risks and also its benefits. But I note that I'm beginning to see civil society not only sort of recognizing and making a case for the benefits of some open type releases, but also getting into the weeds a little bit and saying, well, okay, if it's an open weight release, but you're not really releasing how you got the weights, or you're still restricting how these kinds of open weight releases can actually be used with a legal license, like maybe that's not open enough. I think that's an important trend. I think the other is the technological questions about how quickly what's happening at the frontier will diffuse out. And that has a risk aspect, but it also has a benefit around different business models, less concentration of economic power. So I view this as an important role for further refinement and participation. Yeah, back here.
Thank you so much. I have a couple of questions. One is the issue that, for example, when Senator Schumer invited a bunch of AI executives, there was a couple of union leaders, and we know bosses are different than union members, and there was nobody from EFF, from ACLU, or anybody else. So I wonder, where's the voice of the civil society? Who do we call civil society? That's one. The other one is the astroturfing that happens by some of the local government officials, like city council members and otherwise. I remember I created this very detailed report to my city council in Menlo Park against ALRs, automatic license plate readers. The abuse, the fact that like Piedmont police report shows very little efficacy, and yet they talk about accountability. Don't worry, they are going to be accountable. What does accountability mean? When you research it, at most is a notice requirement. No other penalties, anything. So I think there is a little bit of a misleading in terms of the way people use words like accountability, responsible AI, and otherwise, that the average people who are working for a living, they don't have time to go research those things. So anyway.
Bingo. Good thing. You have a couple questions, and I hopefully have a couple of answers. I'll be quick. I think that's an excellent point, and in some ways, I think the spirit behind your question is very much in sync with my message, which is like, okay, it's nice for people to talk about AI subject to certain ethical constraints or constitutional AI, but I'm asking like, well, what do you mean? Like in law, we argue all the time about, you have a constitutional principle like equal protection, but how do you balance that with changing circumstances? What interpretive method do you use? Are you an originalist? So like, let's go deeper, right? And that relates to the previous question a little bit about how much can be seen. But I'll give you two slightly positive perspectives from my point of view. The first one is that I am noticing growing public concern about an interest in AI, not quite at the same level as the moment GPT-3 was released, but growing. And I suspect that the labor market point I'm making about both the benefits and the drawbacks of automation will encourage that. So as public opinion gets more interested and concerned about this, the role of civil society in some ways is to shape and channel that into productive and useful discussions. The other point is, in international settings, we talk a lot about multi-stakeholder models and when they're appropriate, when they're not. Some countries really push against them. But having now attended the Bletchley Park Summit that the British organized and the French Summit, and engaged a little bit with the Koreans in that summit they had sort of in between, it's very clear that the roles those summits are playing are as a meeting place for government decision makers, the private sector, and civil society. And I have noticed that in all those forums so far, at least, Civil society has had a seat at the table, a chance to shape the discussion, and it feels to me like I just can't imagine this turning out really productively without continuing that. I see an orange sign that says stop. It's pretty scary. Thank you for your questions and attention. Really appreciate it.